Good day, and welcome to Epstein Becker Green's webinar, OSHA Enforcement, Developments to Watch in 2016 and Beyond. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx, and at the end of the program, with time permitting, the speaker will address your questions. You are also welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have a fantastic speaker today. Valerie Butera is a member of the firm in the Employment, Labor, and Workforce Management practice in the Washington, D.C. office of Epstein Becker Green, where she focuses on OSHA and other workplace safety and health issues. She represents clients from numerous industries, including healthcare and life sciences, financial services, hospitality, retail, and technology, among others. She is OSHA 30 certified and has substantial training and experience in process safety management. At this time, I'd like to turn the webinar over to Valerie.
Thank you. And thank you, everyone, for joining me today to talk about what we're expecting from OSHA in 2016. First, we're going to see a significant expansion in the range of industries that OSHA is targeting for enforcement. OSHA has traditionally used the number of inspections conducted by its compliance officers each year as an important measure of the agency's effectiveness. So in the past, compliance officers were most often directed to inspect construction and manufacturing facilities because these inspections tend to be relatively quick and easy and freed up compliance officers to move on to complete more inspections. In other words, enforcement was targeted on these industries because these inspections helped OSHA easily make its numbers. The focus on quick and easy inspections caused many highly hazardous industries to be relatively ignored. On average, a safety inspection takes 22 hours, and a health inspection takes 34 hours. An ergonomics or process safety management inspection can literally take hundreds of hours. To fix this problem, OSHA created the so-called enforcement weighting system, which assigns points to inspections based on their complexity. On September 30th of 2015, OSHA announced that the system has been deployed nationwide for fiscal 2016. Now, compliance officers can be directed to more complex inspections that are assigned many more points than more straightforward inspections, and OSHA can evaluate its performance based on the point system instead of by merely looking at the number of completed inspections. The enforcement weighting system assigns the value, known as an enforcement unit, or EU, to specific categories of inspections and investigations. The number of units assigned ranges from 1/9 of a unit to 8 units. Investigations of non-formal complaints and rapid response investigations, which are usually handled relatively quickly and informally through telephone calls and letters, would receive only 1/9 of an EU, while inspections of so-called significant cases, which generally involve fines of $100,000 or more, would receive 8 units. By rating the complexity of an inspection, OSHA intends to incentivize OSHA compliance officers and area offices focus time and effort on more complex inspections that ultimately will have a greater impact on workplace safety and health. OSHA has announced that it intends to use this program as a mechanism to aid in its program targeting enforcement of the healthcare and nursing care industries. It has assigned a high number of enforcement units to 2 of the main targets of the healthcare initiative: musculoskeletal injuries and workplace violence. Other inspections assigned a high number of enforcement units include process safety management and incidents involving excessive heat exposure. Although there are no OSHA regulations applicable to many of the categories of inspections that have been assigned high numbers of EUs, OSHA has made clear that in order to maximize deterrence, compliance officers are encouraged to issue citations using the general duty clause for any sort of serious hazard, even if there's no applicable OSHA standard. The agency is also increasingly relying on the general duty clause to justify issuing citations for alleged hazards in which there are OSHA regulations in place, but the agency has determined that they are no longer stringent enough to ensure employee safety. And a couple of examples of these are respiratory protection in hospitals, and of course, the permissible exposure limits to certain hazardous chemicals. Although liberal use of the general duty clause is widely criticized, OSHA under the Obama administration has made no apologies for using it however and whenever it sees fit. As I'm sure you're all painfully aware, on January 1, 2015, the reporting requirements for work-related fatalities and severe injuries changed. This change is significant for a number of reasons, not the least of which is that the Occupational Safety and Health Act has a 6-month statute of limitations. In the past, OSHA would not necessarily have learned of these work-related injuries in time to dispatch a compliance officer to the work site to conduct an inspection and issue citations. Now OSHA receives information in real time and can immediately deploy its compliance officers to inspect. After a year of OSHA's promises that an online form for reporting work-related fatalities and severe workplace injuries was quote-unquote coming soon, the agency finally unveiled the form on its website on December 24, 2015. The online form is one of 3 options that employers can use to fulfill the updated fatality and severe injury reporting requirements. Employers also have the options of calling the OSHA office nearest to their work site or calling the OSHA 24-hour hotline to make a report. No matter the option, an employer should be prepared when they're making a fatality or severe injury report to inform OSHA of the following information: the business name, the names of employees affected, the location and the time of the incident, a brief description of the incident, additional information relevant to the incident, the number of fatalities and/or injuries, the object or substance that may have caused the harm, and be very careful here because in a lot of cases you're not going to know, certainly within the 24-hour reporting period, what that cause is. So you should definitely let OSHA know if you don't already, when you make your report. If you don't know what the cause is, you don't know what the cause is. And OSHA will, as I'll discuss in more detail later, have you, more likely than not, have you go and investigate what happened. You'll also need to report whether the harm was a fatality, hospitalization, amputation, loss of an eye, or some combination of these, and the identity of a contact person at your workplace to discuss the matter and their phone number. OSHA will use this information to triage your report, and depending on the type and severity of the incident, will either inspect your facility, ask you to prepare a so-called rapid response investigation report in which you are required to conduct a root cause analysis of the incident that led to the injury, and report your findings and how you have already or plan to address the problem. In some instances, OSHA will determine that you do not really need to report the injury under the reporting rule and will do nothing at all. So what did we learn from year 1? Here you see the statistics published just a few weeks ago that have resulted from the new reporting rule. OSHA received about 12,000 reports under the new rule this year, but it's confident that countless incidents that should have been reported under the rule were not. Blaming the underreporting on ignorance of the rule, the agency has announced that it plans to take steps this year to further educate employers about the requirement. I want to spend a few minutes here talking about those rapid response investigations. As you see here, the majority of reports under the new rule result in rapid response investigations. After you've made your report, OSHA will call you, usually within 24 hours, and inform you that you've been selected to produce such a report. This will be immediately followed by a faxed letter explaining the process in more detail. Unless the incident that led to the injury is extremely complicated, OSHA will give you only 5 days to complete your investigation and submit your report. OSHA provides a non-mandatory form that can be used to submit your findings, but I've universally advised my clients not to use OSHA's form, but rather to create their own response letter attaching evidence of what really happened and how you have already or planned to address the issue that caused the injury. This has been 100% successful for my clients. I think that in order to satisfy OSHA, employers need to be able to tell the whole story, and the non-mandatory form simply doesn't provide a sufficient opportunity to do that. Another important note here, when employees are asked to perform a rapid response investigation, OSHA orders the employer to investigate the incident that caused the harm, determine the root cause of the incident, and produce a written report to OSHA explaining the root cause and how that issue has or is being addressed. There has been great concern among employers that should OSHA decide to come to inspect your facility, either because it was dissatisfied with your report or to ensure that the issue has truly been resolved, and OSHA decides to issue citations, it could use the information contained in your rapid response investigation report as the basis for issuing citations. OSHA has assured employers that it has not and will not do that, and the agency is currently working on an official policy to further assure employers of this. Rather, what employers should expect should this happen is OSHA is going to come to your facility and it'll issue citations based on the facts it gathers during its own inspection, just like a traditional OSHA inspection. Personally, I believe this is another way that the agency is trying to deal with the underreporting issue. OSHA has used the new reporting rule to help the agency adjust its targeting, and it has in fact resulted in OSHA's scrutinizing of a number of employers and industries that the agency has not paid much attention to before. OSHA is expected to expand its reach even further this year when it publishes its controversial electronic record-keeping rule, which we'll discuss later in the program today. Interestingly, though, OSHA's top 10 most cited standards, which you see here, remained unchanged from the last fiscal year. So it seems, at least so far, that the targets may have changed, but the violations the agency is most likely to cite have not. Now moving on to something I'm sure everybody is very concerned about, the probable massive increase in fines for OSHA violations and the newly announced enhanced criminal enforcement for OSHA violations. OSHA has been unable to increase the civil penalties it can impose when an employer is cited for a violation since 1990. But that all changed recently when President Obama signed the Bipartisan Budget Act of 2015, which includes a provision requiring OSHA to significantly increase its civil penalties. A one-time catch-up adjustment will be based on the percentage difference between the Consumer Price Index in October 2015 and October 1990, resulting in a potential penalty increase of 80%. This means that the $7,000 cap on serious violations would grow to $12,600 per violation, and the $70,000 limit on willful and repeat violations would increase to $126,000 per violation. After this initial adjustment is made, OSHA will be required to adjust penalties every year using the annual percentage increase in the Consumer Price Index. Although the agency is not required to take advantage of the full penalty increase, it probably will. OSHA has tried for years to convince Congress to increase the civil penalty penalties the agency can impose when an employer is cited for a violation. Most recently, on October 7, 2015, Assistant Secretary of Labor for OSHA, Dr. David Michaels, told the House subcommittee that the most serious obstacle to effective OSHA enforcement of the law is the very low level of civil penalties allowed under our law, as well as the weak criminal sanctions, and that OSHA penalties must be increased to provide a real disincentive for employers accepting injuries and worker deaths as a cost of doing business. The budget changes go into effect July 1, 2016, and the increased penalties will take effect by August 1, 2016, in all states regulated by federal OSHA. The law does not automatically apply to states regulated by state plans, but since state plan programs must be at least as effective as federal OSHA, state plans are expected to increase civil penalties as well. This change adds yet another powerful weapon to OSHA's growing enforcement arsenal. OSHA under the Obama administration has made liberal use of the General Duty Clause, weighted inspections, new reporting requirements, and all of this has resulted in OSHA inspections of industries and employers that it's never targeted before. Now more than ever, employers should be prepared for a potentially costly encounter with OSHA. Employers are well advised to ensure that safety programs are comprehensive and up-to-date. Ensure that employees receive all necessary safety training, can demonstrate that they comprehend and understand the training, and that all training is well documented. Assess the workplace for hazards and address any identified hazards as quickly as possible. Talk with union representatives or employees at non-unionized facilities about their safety concerns and address any bona fide concerns as quickly as possible. And I want to take a moment here to talk about OSHA's public shaming campaign. Although this tactic is highly criticized and controversial, as employers who receive citations are not even given an opportunity to establish whether citations are valid before OSHA publishes scathing press releases regarding cited employers. The public shaming program is going strong and has in fact become worse recently than it ever was before. Recently, the agency has publicly disclosed citations and fines over $40,000 and included in the press releases the names of the employer's workers' compensation insurers. When asked for the reasoning behind this, OSHA responded that some companies may be deterred more effectively by damage to their corporate image than by fines, and also that workers' compensation insurers have a role in influencing companies to implement safety and health management systems and reduce the risk to employees. So you need to worry about damning press releases now on top of everything else, which may encourage your workers' compensation insurer to pressure you to put safety programs of their choice in place to improve employee safety, all before you've even had a chance to attempt to prove your innocence. OSHA has long been criticized for failing to bring criminal charges against employers in the wake of serious incidents, frequently involving casualties. This is particularly true in cases where both EPA and OSHA inspect the same incidents, and OSHA elects not to pursue criminal prosecution while EPA brings criminal charges. A prime example is the tragic incident at BP's Texas City refinery in March 2005, in which 15 employees were killed and 100 employees were seriously injured. OSHA and EPA investigated the incident, but only EPA brought criminal charges. Increasing OSHA's enforcement power even further, on December 17, 2015, the Department of Justice, or DOJ, announced a partnership with the Environmental Crime Section of DOJ and the Department of Labor to criminalize worker safety violations. This move comes on the heels of a September 2015 memorandum from Deputy Attorney General for the DOJ, Sally Quillian Yates, delivered to all 93 United States attorneys, in which DOJ adopted new initiatives to strengthen its pursuit of all manner of individual corporate wrongdoing. Basically, that memo said we want individuals. When we weren't, that was really focused on financial crimes, but this is now bringing it to worker safety violations as well. So they're actually looking for some kind of bad actor that they can press charges against. DOJ has previously sought to rely upon environmental statutes to enforce workplace violations, but it's never taken an action this extreme. DOJ took this step for two reasons. One, environmental offenses often occur in conjunction with worker safety violations, and criminal environmental statutes can be charged as felonies, while OSHA violations are mere misdemeanors. DOJ and DOL inked a Memorandum of Understanding encouraging federal prosecutors to work with DOJ's Environmental Crime Section to pursue worker violations as environmental crimes. Using Title 18, the Federal Penal Code, prosecutors can demand larger fines and prison sentences for worker safety violations and effectively increase deterrence. The DOJ announcement pointed out that the Environment and Natural Resources Division of DOJ had already been engaged in strengthening its efforts to pursue civil cases that involve worker safety under environmental statutes. So this development seems like a next logical step. Among the internal changes to DOJ's investigation practices are one requiring civil division attorneys to share information with criminal division attorneys, and a requirement that criminal division attorneys, should they decide not to prosecute, explain to a supervisor why they did not seek charges against an individual company wrongdoer. By working in concert, the goal of both agencies is to increase the effectiveness of criminal prosecutions of worker safety violations. When it comes to workplace safety, I cannot emphasize enough that employers can no longer be complacent. Rather, you need to be proactive in ensuring that you've done all you can to protect your employees' health and safety. Companies should consider conferring with counsel to conduct an attorney-client privilege safety and health audit in their workplaces. If companies conduct an audit for purposes of obtaining compliance advice, it is completely protected from disclosure to OSHA. Otherwise, OSHA can request your audit report during an inspection and use it as a map to potential hazards in your facility. In my experience, most employers wait until they've received an OSHA citation before conducting an audit of their facility or facilities. This is certainly better than taking no action at all. Oftentimes, OSHA targets employers with multiple facilities, inspects one facility, then issues citations at multiple other facilities owned by the same employer, which gives OSHA the chance to not only issue more citations, but to issue costly repeat citations based on similar violations that it found in inspections of the employer's other facilities. This has hit retail very hard. It's hitting fast food franchises really hard right now. So if you do have multiple facilities, an audit can help you identify any systemic problems and address them before OSHA shows up issuing citations that will soon come with enormous fines and the prospect of a prison sentence. I also highly encourage employers to consider an attorney-client privileged audit before OSHA has visited any of your facilities, so that you have a chance to address problems before they become citations. Conducting an audit costs a small fraction of the cost of defending an OSHA citation. And if EPA or OSHA should arrive at your work site, you should contact OSHA counsel immediately. Inspections concerning environmental hazards carry even higher stakes than ever, and you need to be well advised and prepared. Taking such proactive steps not only improves the health and safety of your workplace, they could be the actions that prevent a company from facing millions of dollars in OSHA fines under environmental statutes and a prison sentence. Now we'll turn to joint employer scrutiny. This has been quite a controversial topic lately. On July 15, 2014, OSHA issued a policy memo to its field offices outlining when a compliance officer visiting a work site should enlarge the inspection to include temporary agencies providing workers to the site. Generally, compliance officers were instructed that whenever a temporary worker was exposed to a violation, the compliance officer should determine whether the temporary agency was aware of the hazards or could have known about them. As a result, OSHA inspections involving temporary employee agencies increased approximately 400%. Though very few inspections resulted in citations being issued to temporary employee agencies, rather, OSHA has cited many host employers for alleged violations related to temporary workers that found no bases for issuing citations to the temporary staffing agencies involved. But like many other OSHA enforcement initiatives, this is very likely to change this year. The National Labor Relations Board, NLRB, recently issued its decision in Browning-Ferris Industries, adopting new liberal standards for determining when a company will be held to be the joint employer of another company's employees, whether they are leased, temporaries, or providing services under their primary employer's contracts with customers. While the Occupational Safety and Health Act's definition of employer is not identical to the definition of the National Labor Relations Act, there can be no doubt that the NLRB's Browning-Ferris decision is likely to influence OSHA's approach to inspections and citations involving temporary or contract employees. When OSHA's Temporary Employee Initiative was announced in 2013, Dr. David Michaels declared that temporary staffing agencies and host employers share control over the employee and are therefore jointly responsible for temporary employees' safety and health. It is essential that both employers comply with all relevant OSHA requirements. Although inspections under the Temporary Employee Initiative have occasionally resulted in citations being issued to both the host employer and the temporary staffing agency, more often than not, only the host employer is cited because it's perceived as having a greater ability to control or prevent the temporary employee's exposure to a hazard. Should OSHA adopt the reasoning of the Browning-Ferris decision, this trend will surely change, significantly increasing staffing agencies' exposure to OSHA citations, even when the staffing agency had no control over the workplace or awareness of the hazard. Similarly, contractors will face increased exposure to OSHA citations should OSHA follow Browning-Ferris. Under the agency's multi-employer worksite citation policy, OSHA may cite an employer for hazards that other employers' employees were exposed to when OSHA finds that the employer controlled the hazard, created the hazard, or was responsible for correcting the hazard. Applying the reasoning of Browning-Ferris to this policy could considerably expand the number of employers cited, treating multiple contractors as controlling employers, regardless whether they had any real control over the hazards at the work site. Shortly after the Browning-Ferris decision came down, the International Franchise Association obtained and linked to the media an internal OSHA document in which the Department of Labor was asked whether OSHA could cite both a franchisor and a franchisee when violations were found in a franchisee's establishment. The document provided guidance for compliance officers inspecting franchises to help determine whether the franchisor could be prosecuted along with a franchisee as a joint employer. Questions were things along the lines of whether safety training was consistent across all the franchises, how often the franchisor visits the different franchisees, and other questions aimed at determining the level of involvement with health and safety that has been exercised by the franchisor. Purportedly, OSHA has already subpoenaed such documents in an ongoing inspection. Although OSHA recommends creating agreements that explicitly detail which employer is responsible for various safety obligations, it is also said that such documents will not control its decisions in terms of which entities receive citations. The bottom line is that in order to fully protect your business and everyone who works there, you should provide the same training, personal protective equipment, and the like to your own employees, temps, and contractors. When it comes to health and safety, treat everyone who works in your facility as one of your own employees. And whistleblowing. As usual, it is continuing to rise. So OSHA's anti-retaliation programs are going strong. The number of complaints has risen every year, with health and safety complaints rising the most dramatically. The program is terribly underfunded, so OSHA is significantly behind in processing complaints. In order to present their best defenses, employers need to be mindful of this lag and retain any and all documentation related to the alleged retaliation. Most whistleblower cases settle, and the agency rolled out a new alternative dispute resolution process to encourage settlement earlier this year. But you should still save those documents should OSHA decide to pursue litigation. OSHA released proposed best practices for protecting whistleblowers and preventing and addressing retaliation, and it asked for public comment on the document. The initial document included a fairly comprehensive program involving employers and employees and extensive training and monitoring. It is unclear to what extent the final version of the best practices will actually be adopted. If an employer does not already have a program like this in place, it could be incredibly cost and time-intensive to change the culture of the company in this way, particularly if an employer has many locations and may require safety consultants to assist in implementing the plan. And it could be entirely unrealistic for small businesses to adopt such a plan. Again, there would be implementation costs, but there would also be significant administrative costs, as small businesses may lack the resources to bring in safety experts to implement the program. They're likely going to have to do it themselves. I think the best practices certainly provide worthwhile guidance, but they're non-mandatory, and I'm unsure whether they'll make a real impact on safety culture. Employees today know their whistleblower rights and do not hesitate to use them. Particularly savvy employees are now filing anti-retaliation complaints under multiple statutes. I do not expect that to change anytime soon. Many of you have likely dealt with whistleblower claims in the past. They are very difficult to avoid these days. It is important to note going forward that the way these claims are analyzed is a little different now than they were before. On April 20th, 2015, the acting director of the Directorate of Whistleblower Protection Programs sent a memo to all regional administrators and whistleblower protection managers seeking to, quote, clarify the investigative standards for OSHA's whistleblower investigation, unquote. The memorandum concludes that based upon OSHA's regulations, the reasonable cause standard applies for determining whether to issue merit findings when there is a reasonable cause to believe that a violation of the relevant whistleblower statute has occurred. The threshold that OSHA must meet to find reasonable cause that a complaint has merit requires evidence in support of each element of a violation and consideration of the evidence provided by both sides during the investigation, but it does not generally require as much evidence as would be needed at a trial. Ultimately, OSHA must be convinced that a reasonable judge could rule in favor of the complainant. Could is the key word here. OSHA is not required to provide all the evidence a judge may need to determine that a violation actually took place. In making this determination, OSHA will make credibility determinations to evaluate whether a reasonable judge can find in complainant's favor. OSHA does not need to resolve all possible conflicts in the evidence or make conclusive credibility determinations to find reasonable cause to believe that a violation occurred. Should OSHA dismiss a case, finding that it lacks merit or it's not suitable for litigation, it must state that the Secretary of Labor has determined the complaint lacks merit and explain why. And now we have rulemaking activities. In the Department of Labor's most recent list of regulations, OSHA, of all the different parts of the Department of Labor, had the most activity going on in the regulatory arena. And what do we expect to actually happen before the end of the Obama administration? First, it looks like the very, very long-awaited silica rule will make it through. Although this rule has been in the making for many years, it is on it's one of OSHA under the Obama administration's top rulemaking priorities, and the new regulation is expected to be published sometime next month, although there's a lot of people saying they think it's going to take a little bit longer than that. The rule is likely to include comprehensive requirements for minimizing employee exposure to silica, including exposure monitoring, medical surveillance, and worker training. Next, it appears likely that the walking, working surfaces, and personal fall protection systems rule, although temporarily withdrawn from the final approval process at the Office of Management and Budget, will soon be resubmitted and is likely to be published before the end of the Obama administration. The agency has been less than clear about its reasons for the temporary withdrawal, but many speculate it was done to ensure that, if nothing else, the silica rule makes it through. Slips, trips, and falls are among the leading causes of work-related injuries and fatalities, however. So this is another one that's very important to the Obama administration. In 1990, OSHA published a proposed rule addressing slip, trip, and fall hazards and establishing requirements for personal fall protection systems. But as the years have passed, improved technologies and procedures have become available to protect employees from these hazards. In light of these developments, OSHA published a notice to reopen the rulemaking for comment in May of 2003. The agency published a second proposed rule on May 24, 2010, which reflected all current information and improved consistency with other OSHA standards. Next, we have the clarification of employers' continuing obligation to make and maintain accurate records of each recordable injury and illness. OSHA is proposing to amend its record-keeping regulations to clarify that the duty to make and maintain accurate records of work-related injuries and illnesses is an ongoing obligation. The duty to make and maintain an accurate record of an injury or illness continues for as long as the employer must keep the record. The duty does not expire if the employer fails to create the necessary records when first required to do so. OSHA is issuing this proposed rule because of the decision of the U.S. Court of Appeals for the District of Columbia Circuit in AKM LLC versus Secretary of Labor. This was a 2012 decision that basically held that the Occupational Safety and Health Act's 6-month statute of limitations was just that, a 6-month statute of limitations, and that OSHA could not add document retention periods as a way of endlessly extending the statute of limitations. This is still in the proposed rule stage, but it too is of great importance to the agency, and I expect OSHA will do whatever it can to get this one published before the end of this administration as well. And although it is not characterized as a rule, or not an actual rulemaking, another major OSHA initiative, which could be characterized by some as backdoor rulemaking, is certainly worth discussing. I'm sure many of you are familiar with the Dollar Tree stores' problems with OSHA over the past several years. This was an instance where OSHA went after an employer with multiple facilities and issued countless repeat citations at a number of stores based on similar alleged violations discovered at other stores. Dollar Tree recently entered into a corporate-wide settlement agreement with OSHA to resolve citations arising from 13 different inspections, many involving blocked emergency exits, obstructed access to exit routes, electrical equipment, and improper storage of merchandise. The settlement applies to some 2,400 Dollar Tree stores throughout the United States that are subject to regulation by federal OSHA, and state plans with Dollar Tree stores located in their jurisdictions have been strongly encouraged to adopt the parameters of the settlement agreement as well. Dollar Tree must pay $825,000 in fines to resolve the citations, but that's really just the beginning. In addition, the retailer must provide immediate safety training in all stores in a manner that all employees are able to comprehend. They must abate the issues identified in inspections as quickly as possible, issue a newsletter regarding health and safety issues to its employees on at least a quarterly basis, submit to multiple safety audits at stores selected by OSHA, and quickly address any issues identified by the audit. Dollar Tree must also put a number of additional administrative and engineering controls in place. But here's where the potentially backdoor rulemaking comes in. Perhaps the most onerous element of the agreement is that it requires the employer to adopt a safety and health program, focusing on the core elements included in OSHA's Safety and Health Program Management Guidelines. The guidelines were originally published in 1989, but major revisions have recently been published, and OSHA is currently welcoming comments on the new version. And commenters have until February 15th to get comments in. Dollar Tree must design a program that focuses on the core elements set forth in the 1989 guidelines, as the revised version has not yet been finalized. Specifically, the retailer must demonstrate its commitment to workplace health and safety, involve employees in the safety and health program, identify health and safety hazards, control health and safety hazards, provide education and training for all employees related to the safety and health program, and evaluate the safety and health program. Essentially, the settlement agreement requires the employer to create a culture of safety throughout the entire organization. Although Dollar Tree is required to create a program addressing all of these elements, the guidelines aren't prescriptive. OSHA recognizes that every business is different, and it offers a non-exhaustive list of possibilities that employers could choose from when creating a safety and health program that comports with every element of the guidelines. This move is noteworthy because, like the whistleblower best practices, these guidelines weren't intended to be OSHA standards. When the proposed revisions were shared with the public, the general reaction was that the guidelines were great in theory, but really just seemed to be a way for OSHA to create an optional injury and illness protection program. Creating an injury and illness protection regulation has been a long-standing goal of the agency, but they've never been successful. But with the Dollar Tree settlement, we see that employers should expect OSHA to more frequently demand the incorporation of the guidelines in future settlement agreements. The agency has publicly announced that adoption of the guidelines and the creation of a safety culture is one of its top priorities, and it seems OSHA has found a way to accomplish that. And last but certainly not least, we have the improved tracking of workplace injuries and illnesses final rule, which is expected in March. We'll see. It's been with the Office of Management and Budget for some time now, and it's extremely controversial, so I would expect it to take some time to get through. Many employers are required to keep logs of work-related injuries and illnesses. Traditionally, these logs have been hard copy documents Excuse me, guys. Okay, traditionally, these have been hard copies that OSHA would only be likely to study if it visited a site for an inspection. Employers will soon be required to submit these records to OSHA electronically on a frequent basis. The data will be reviewed, compliance officers dispatched to inspect employers with high injury and illness rates, and the records will then be made publicly available on the Internet. After supposedly scrubbing the information of all identifiable information, OSHA will make employers' injury and illness information public through a website. The website is designed to enable anyone to search employers' injury and illness records. The public will be able to search how many injuries and illnesses occurred at each workplace, the title of the affected employee, and the circumstances related to each incident. Because the circumstances of each incident will be included in the searchable data, it's entirely possible that the privacy rights of the affected employee will be breached. Although the cells of the worksheet containing the employee's name will be deleted before publication, the public can gather much just from reading the circumstances of the incident, the titles of the injured person, and location of the work site. The regulation gives me even more heartburn when I think about the healthcare industry. Consider, for example, a hospital with a workplace violence incident incited by a patient. More than likely, the identity and perhaps even protected health information of the patient will be included in the description of circumstances related to the incident. So now we're looking at OSHA inadvertently disclosing both employee and patient information in violation of HIPAA, the Privacy Act, and other statutes and regulations. Although OSHA insists that private information will be scrubbed from the data before it's released to the public, it has not identified a means for doing so, and it has had quite some time to tell us what it's going to do. Nor has it established how it will accomplish this task when it's already lacking in both the physical and physical resources necessary to do the job. One thing that might bring some relief, at least temporarily, when OSHA rolled out the new reporting rule, it expected approximately 25,000 reports per year. But it took the agency nearly a year to create a fairly simple, workable online form for making those reports. Under the record-keeping rule, the agency will be collecting hundreds of thousands of electronic documents. If it took a year for OSHA to create a simple form for the reporting rule, where they're only expecting 25,000 reports, how on earth is OSHA going to create a workable online system for the tremendous amount of information it seeks under the record-keeping rule? Another concern for employers, though, is the possibility, when this thing does get up and running, of being painted as a bad actor, apathetic about employee health and safety, as the injury and illness reports do not provide the public with the full context of what happened. Finally, the public release of employers' injury and illness data will enable unions to easily identify employers with higher than average numbers of injuries and illnesses as targets for unionization. Clearly, this rule is going to cause chaos for all employers that must deal with record keeping. When the rule is released, which again supposedly is going to be in March, we will move quickly to provide you with guidance about how to comply with the requirements of the new rule while providing as much protection as possible to the privacy rights of everyone involved. Every employer should be concerned about OSHA now. The agency has been incredibly successful in accomplishing its goal of extending its reach and increasing its enforcement power. Employers should be evaluating their work sites, talking to their employees or union reps, reviewing policies. Basically, you need to do a top-to-bottom evaluation of health and safety in your workplace. As I mentioned before, you should also seriously consider reaching out to outside counsel to arrange for an attorney-client privileged OSHA compliance audit. The time for complacency in employee health and safety is over. Employers are well advised to be proactive in regards to health and safety rather than waiting to worry about it when OSHA shows up at the door. Because by the time that happens, it's going to be far too late for you to make improvements in your workplace that will improve worker safety, health, and morale, and help reduce the possibility of receiving what promise to be very costly OSHA citations and possible prison time. Our award-winning OSHA Law Update blog is available at www.oshalawupdate.com. Please reach out if there is a topic you want to learn about. And I'm happy to either send you a blog that I've recently written, or if I haven't written about it already, I will write one on the topic. And I think we have a few minutes if there's any questions.
Yep, great. So that was wonderful information. Thank you, Valerie.
My pleasure.
And before we dig into questions, I just want to remind everyone that you are welcome to submit questions by using the Q&A feature provided by WebEx. So if you'd like to do so, please go ahead now and we'll start digging through the questions. I'll also go ahead and remind everyone that in 2 to 3 business days following this webinar, we will communicate the availability of the webinar recording and slides. And while we answer questions, I'll go ahead and move on to the slides so you have Valerie's contact information if you would like to contact her following the webinar. So the first question we have reads, we have remote employees as well as employees who work from home 1 or 2 days a week. Are there any OSHA considerations for those employees?
There are actually several. And in fact, I won't have time probably to answer this question in its entirety, so please feel free to give me a call after the webinar and I'll tell you a little bit more. But things like if your employees that work remotely are using their automobile, although OSHA does not have safe driving standards, it does have a lot of safe driving recommendations for employees. And OSHA has a tendency to point to these recommendations and guidance documents that it issues and says, well, you should be meeting that standard, and if you're not, we're going to cite you under the general duty clause. So you want to be familiar with the safe driving standards. Another one that offices haven't really had to worry about much in years is ergonomics. You want to make sure that your employees' home offices are set up in an ergonomic fashion. I sincerely doubt that OSHA would go into people's homes and start checking on this, but they are going after ergonomics, again, using the general duty standard now because they've never been able to create an effective ergonomic standard. So just to be on the very safe side, I would definitely, there's lots and lots of information on how to set up an ergonomic work site available out there, including on OSHA's website. Take a look at that and just make sure, you don't run into a glut of, say, carpal tunnel syndrome or something like that. Again, I don't think OSHA would investigate that kind of thing. They're more concerned about ergonomic issues in hospitals and that kind of thing. But to be at your very safest, I would check it out and make sure that your employees have the gear that they need to work safely and without becoming injured.
Great. Okay, and then another question, which I know came in at the beginning of the webinar in relation to the first few slides, says, what are your thoughts on completing this form when it uses the term victim to describe the injured employee?
Yeah, I don't like the form at all. I don't know any employer-side attorney that does, and that for me is yet another reason just not to use it. What I do with my clients is we compose, well, first of all, we rapidly investigate, and then we usually compose a letter, and attached to the letter exhibits. We use declarations to support the facts that are uncovered in interviews and things of that nature. Say if you have a fix that you're making, but for instance, you have to have a special part for it and you're still waiting for the part, submitting the purchase order for the part, things like that. As I said, I've done that 100% of the time with these rapid response investigation reports, and none of them have resulted in any inspection or any kind of problems whatsoever. So I would just avoid that thing entirely, and I do not like the use of the term victim. I mean, they're an injured employee. That's how I would put it.
All right, great. Okay, then we also have, how often do you suggest the company should do an outside audit? We have our store managers look for potential problems monthly, and these are documented.
That's an excellent practice, number one. Two, I would say, the companies that I've done audits for, like I said, unfortunately, usually they do it after they've received a citation. But once they get in the groove of doing them, I'd say we do them probably once every 2-3 years. It doesn't need to be something that you're doing constantly, but especially with something like this, like increased enforcement, or when OSHA has a national emphasis program, for instance, which is where they're focused on one particular industry, and you're concerned that you might get hit. It's good, just to have someone come in with a fresh pair of eyes and go through, and and also the expertise, and basically pretend to be an OSHA inspector and identify for you everything that you might be missing. But again, that's a wonderful practice that you're having people do that monthly and keeping it on file. That's excellent.
Great. And then we have, if our company sponsors a customer event and a customer somehow gets injured at the event, does that fall under our workers' compensation?
No, that workers' compensation and OSHA are strictly employer-employee. If it was an employee who was injured at the event, that would be a different story. But no, not a visitor.
Okay. And if you were to get an OSHA citation this year, is there a time frame where the same offense is not considered a repeat offense? It's
within 5 years. So after the 5-year period is up, which is, it's long. They've extended it recently. After the 5-year period is up, it's no longer considered a repeat, if I understood that question correctly.
Okay. And how long should we save our documentation on incidents?
I tend to say, I save things, it's not my home practice, but when it comes to incidents and anything safety related, there's, and this is another one that could be a long answer. Depending on what you have to do with your record keeping requirements, because some employers have to do that and some employers don't. That makes a difference. And then also, I would say, just generally speaking, and maybe this is because I've done a lot of process safety management work, but in process safety management, you hold on to the documents for the life of a machine. So I would certainly keep incident reports for the entire time that the employee works for you, and then probably after that as well, just so that you're always in a good position.
Okay, wonderful. And then I think we have time for just 2 more.
Okay.
So I have, do we need to put our contract employees on our OSHA log, or do they go on their own company's log?
I just have started running into that question more and more lately. The most recent OSHA guidance that I have seen is that the person would still go on, the contractor would go on the contract employee would go on the contractor's log, is what I'm trying to say. That is the most recent guidance that I've seen, but again, it is getting murky. That's an excellent question, and I think, at some point we might see that change.
Great, wonderful. And then the final question is, do you have a website that you can refer people to where they can make comments?
Sure. Probably the easiest thing to do would be to go to the blog, which again is the OSHALawUpdate.com. I also am very active on LinkedIn, so if you want to have a conversation with me there, or obviously email me, call me, yeah, I'm always happy to engage.
Wonderful. And, thank you everyone for all of your questions. Sorry we don't have enough time to get to all of them, but thank you for answering all those questions and for your time today, Valerie. And I want to thank everyone else for joining us. This does conclude today's webinar, and approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you and good day.